I never thought I would end up in court over a parking space. But when you buy a house in Riverside, California, you learn pretty quickly that anything can happen when a homeowners association gets involved. My name is Marcus Quinn, and I work as a software engineer for a tech company downtown. I bought my house on Magnolia Lane about 3 years ago, a nice 2-story craftsman with a decent yard and what I thought was a peaceful neighborhood. The place cost me nearly everything I had saved up, but it was worth it to finally have something that was mine. Or so I thought. The trouble started on a Tuesday morning in March when I woke up to find my driveway empty. My black Honda Accord, which I had parked there the night before, was gone. At first, I thought I had been robbed. My heart raced as I stood there in my pajamas and slippers, staring at the empty concrete slab where my car should have been. I immediately pulled out my phone and was about to call the police when I noticed a bright orange sticker on my mailbox. The sticker read, "Vehicle towed for violation of HOA parking regulations. Contact Meadowbrook HOA for information." I felt my blood pressure spike. I had parked in my own driveway, my own property. How could the HOA possibly have any authority to tow my car from my own driveway? I marched back inside, threw on some clothes, and grabbed the thick folder of documents I had received when I bought the house. Somewhere in there had to be information about this Meadowbrook HOA. After 20 minutes of searching, I found a phone number. I dialed it immediately, not caring that it was only 7 in the morning. The phone rang 5 times before someone picked up. Meadowbrook Homeowners Association, this is Patricia speaking. Yes, hello, my name is Marcus Quinn. I live at 847 Magnolia Lane, and my car was towed from my driveway this morning. I need to know why and how I can get it back. There was a pause, then the sound of typing. Oh yes, Mr. Quinn. Your vehicle was towed for violating the new parking regulations that went into effect last week. What new parking regulations? I never received any notice about new regulations. The notice was sent out via email to all residents 2 weeks ago, Patricia said in a tone that suggested this was somehow my fault. I never got any email. And even if there were new regulations, I was parked in my own driveway. How can that possibly be a violation? More typing. According to our records, Mr. Quinn, your vehicle was parked partially on the street. The new regulations prohibit any vehicle from being parked on Magnolia Lane between the hours of midnight and 6 in the morning. I closed my eyes and tried to remain calm. My car was in my driveway. It might have been a few inches over the property line, but it was mostly in my driveway. According to our records and the photographic evidence, approximately 8 inches of your vehicle's rear bumper was extending onto the street. That constitutes a violation. Your vehicle has been taken to Riverside Towing on Industrial Boulevard. You will need to pay the towing fee of $375 plus a $50 HOA fine before you can retrieve it. $425. Are you kidding me? I understand your frustration, Mr. Quinn, but rules are rules. If you would like to contest this, you can submit a written appeal to the HOA board. The next board meeting is scheduled for 3 weeks from now. 3 weeks. I need my car to get to work. I need it today. Then I suggest you pay the fees, Mr. Quinn. Have a nice day. She hung up before I could respond. I stood there holding my phone, feeling a mix of anger and disbelief. This could not be legal. There was no way an HOA could just tow someone's car from their own property for being a few inches over a line. I called an Uber to take me to the towing company. The driver, a friendly guy in his 50s named Ray, listened to my story during the 20-minute drive and shook his head sympathetically. "HOA man," he said. "I would never buy a house with an HOA. I have heard too many horror stories." At Riverside Towing, I was greeted by a bored-looking clerk behind a scratched plexiglass window. I explained why I was there, and she pulled up my information on her computer. "That will be $375, she said. "This is ridiculous. My car was in my own driveway." She shrugged. "Take it up with whoever called us. We just tow what we are told to tow. Cash or card." I reluctantly handed over my credit card, fuming as I watched the charge go through. When I finally got my car back and drove home, I was already an hour late for work. I called my boss and explained the situation, and thankfully he was understanding. But I was not about to let this go. $425 was not pocket change, and the principle of the matter infuriated me. When I got home that evening, I started doing research. I pulled up every document related to my home purchase, including the title, deed, and property survey. I also searched through my emails for anything from the HOA. There was nothing. No notice about new parking regulations, no emails from Meadowbrook HOA at all. As I was reading through the property documents, something caught my eye. The survey showed my property boundaries, but there was also a notation I had never paid much attention to before. It referenced an easement document recorded back in 1967. I did not know what that meant, so I kept digging. After another hour of research, I found something interesting. The original developer of Magnolia Lane had been a company called Riverside Meadows Development Corporation. According to county records, this company had built the entire subdivision back in the 1960s, including the streets. Normally, developers build streets and then dedicate them to the city, which takes over maintenance and ownership. But according to what I was reading, Magnolia Lane had never been dedicated to the city of Riverside. It was still listed as a private street. I sat back in my chair, my mind racing. If Magnolia Lane was a private street, who owned it? I spent the next 2 hours going through property records and land deeds. The trail was confusing and went through multiple corporate entities and transfers, but eventually, I traced it forward to a property management company that had dissolved in 1998. After that company dissolved, its assets were supposed to have been distributed according to a settlement agreement. I finally found the settlement document archived in the county records system. According to the agreement, all of the undeveloped land and private streets owned by the dissolved company were to be divided among the property owners adjacent to those streets. That meant that Magnolia Lane should have been divided up among the homeowners who lived on it. My heart started pounding. Could it be possible that I actually owned a portion of the street in front of my house? I looked at the property descriptions in the settlement document and compared them to my deed. The settlement said that each property owner would receive the portion of the private street directly abutting their property, extending to the center line of the street. According to my property survey, my lot was 75 feet wide. That meant I should own a 75-foot section of Magnolia Lane, from my property line to the center of the street, but my deed did not mention any of this. I read through it 3 more times, looking for any reference to the street or the settlement, but there was nothing. Either the title company had missed this when I bought the house, or someone had made an error in the chain of title. I needed help. This was way beyond my understanding of property law. The next morning, I called a real estate attorney whose name I found through an online search. Her name was Jennifer Mathies, and her office was in downtown Riverside. I explained the situation to her receptionist and was told that Jennifer could see me that Friday afternoon. When Friday came, I took half a day off work and drove to Jennifer's office. She was a sharp-looking woman in her 40s with short, dark hair and an air of competence. I laid out everything I had discovered, showing her the property documents, the survey, the settlement agreement, and my deed. She listened carefully, occasionally making notes. When I finished, she leaned back in her chair and steepled her fingers. "This is very interesting, Mr. Quinn. If what you are saying is accurate, and if the settlement agreement is valid, then you may indeed own the portion of Magnolia Lane in front of your property. The fact that it is not mentioned in your deed is problematic, but not necessarily fatal to your claim. Sometimes these things get missed in title searches, especially when dealing with older property transfers." "So what do I do?" I asked. "First, I need to do my own research to verify everything you have found. If it checks out, we will need to file a quiet title action. That is a lawsuit that asks the court to clarify who owns the property. It can take several months, and it will cost money, but if you win, the court will issue a judgment that officially recognizes you as the owner of that portion of the street." "How much are we talking about?" "My retainer for something like this is $5,000. The total cost will depend on how complicated it gets, but you should budget for at least $10,000. I swallowed hard. $10,000 was a lot of money, but I was angry enough and stubborn enough to pursue this. If I really did own the street, then the HOA had no right to tow my car, and I wanted everyone to know it. "Let's do it," I said. Jennifer smiled. "All right. Give me a couple of weeks to research this thoroughly, and then I will let you know what I find." I left her office feeling cautiously optimistic. At least I was doing something instead of just accepting the HOA's ridiculous rules. 2 weeks later, Jennifer called me. "Marcus, I have good news. I have verified everything you found, and I believe you have a very strong case. The settlement agreement is valid and was properly recorded. The portion of Magnolia Lane in front of your house should have been transferred to you or to the previous owners of your property. Either way, you have a legitimate claim to ownership." "That is great," I said, feeling a surge of excitement. "I am going to draft the quiet title complaint and file it with the court. I will also send notice to the HOA and to the city of Riverside, since they may claim an interest in the street. This is going to take time, but I think we are going to win." Over the next few weeks, Jennifer filed the lawsuit and sent out all the required notices. The HOA's response came quickly and was exactly what I expected. They filed a motion to dismiss, arguing that I had no basis for claiming ownership of the street and that my lawsuit was frivolous. The city of Riverside filed a more measured response, saying they took no position on the ownership issue but wanted to be kept informed of the proceedings. The real fireworks started when the HOA board president, a woman named Brenda Hartwell, showed up at my door one Saturday morning. I was in the garage organizing some tools when I heard the doorbell ring. I opened the door to find a woman in her mid-50s with blonde hair styled in a stiff bob, wearing a pastel pink blazer and pearls. She had the kind of smile that did not reach her eyes. "Mr. Quinn, I am Brenda Hartwell, president of the Meadowbrook Homeowners Association. I was hoping we could have a word." "Sure," I said, not inviting her in. "What can I do for you?" Her smile tightened. "I understand you have filed a lawsuit against the HOA claiming that you own Magnolia Lane. I wanted to discuss this with you personally and see if we can resolve this matter without going through expensive litigation." "I am listening." "First, I want you to understand that the HOA is not trying to harass you or make your life difficult. We are simply enforcing the rules that were put in place for the benefit of all residents. The parking regulations exist because we had complaints from residents about cars blocking the street and creating safety hazards. Mrs. Hartwell, my car was in my driveway. It was barely touching the street. According to our measurements and photographs, it was 8 inches onto the street. That is a violation. Even if that is true, I do not think the HOA has any authority to tow vehicles from the street. I have done some research, and I believe I own the portion of the street in front of my house." Her expression hardened. "That is absurd, Mr. Quinn. Magnolia Lane is a public street maintained by the city of Riverside." "Actually, it is not. It is a private street that was never dedicated to the city. And according to a settlement agreement from 1998, ownership of the street should have been transferred to the property owners. I have lived in this neighborhood for 20 years, and I have never heard anything about the street being privately owned. You are wasting everyone's time and money with this frivolous lawsuit." I felt my temper rising but kept my voice calm. "Mrs. Hartwell, if the lawsuit is so frivolous, then you have nothing to worry about. The court will dismiss it, and that will be the end of it. But if I am right, then you and the HOA owe me an apology and a refund of the money I had to pay to get my car back." She stared at me for a long moment, her jaw tight. "You are making a big mistake, Mr. Quinn. The HOA has resources and connections. We will fight this and we will win. And when we do, we will seek to recover our legal costs from you. I guess we will see what the court says." She turned on her heel and stalked back to her car, a white Lexus SUV parked at the curb. I watched her drive away, feeling both vindicated and nervous. She was right about one thing. This was going to be expensive and time-consuming. The months dragged on. Jennifer filed responses to the HOA's motions, and there were several hearings where the judge listened to arguments from both sides. The HOA's attorney, a slick guy in an expensive suit named Richard Pemberton, argued that even if the street had once been private, it had been used as a public thoroughfare for so long that the city had acquired ownership through adverse possession. Jennifer countered that there was no evidence the city had ever claimed ownership or performed maintenance beyond basic road repairs, and that adverse possession did not apply to public entities in this situation. During this time, the HOA continued to harass me. I received 3 more notices about supposed violations. My lawn was a 1/4 inch too long, my trash cans were left out 15 minutes past the allowed time, and my house number needed to be repainted because it was faded. Each violation came with a $50 fine. I paid none of them and added them to my list of grievances. Then one day in August, I came home from work to find another orange sticker on my mailbox. My car had been towed again. This time, I had parked it entirely in my driveway, at least 6 inches back from the property line. I took pictures with my phone showing exactly where the car had been and immediately called Jennifer. "They towed my car again," I told her. "And this time I made absolutely sure it was not on the street." "Send me the pictures," she said. "We are going to file a motion for a temporary restraining order to stop them from doing this." 2 days later, we were back in court. The judge, a stern-looking man in his 60s named Judge Harold Mayer, listened as Jennifer argued that the HOA was engaging in harassment and retaliation because of the pending lawsuit. Richard Pemberton argued that the HOA was simply enforcing its rules, and that Mr. Quinn was a repeat violator who refused to comply with reasonable regulations. Judge Mayer looked at the photographs I had taken. "Mr. Pemberton, can you explain to me how a vehicle that is entirely within the property owner's driveway violates your parking regulations?" Pemberton cleared his throat. "Your Honor, the HOA's position is that the vehicle was creating a visual obstruction and violated the aesthetic guidelines in the CC and RTCS." "I see. And where in the CC and RTCS does it say that a vehicle parked in a driveway creates a visual obstruction?" Pemberton shuffled through his papers. "Section 12. Subsection 4 states that no property owner shall maintain any structure or object that creates a visual blight or detracts from the overall aesthetic of the neighborhood. And you are arguing that Mr. Quinn's vehicle, a standard Honda Accord parked in his driveway, constitutes a visual blight. The HOA board has broad discretion to interpret the aesthetic guidelines, Your Honor. Judge Mayer removed his glasses and rubbed his eyes. Mr. Pemberton, this is starting to look like harassment. I am going to grant the temporary restraining order. The HOA is prohibited from towing Mr. Quinn's vehicle unless it is parked in a manner that clearly violates a specific written regulation, and only after providing Mr. Quinn with 24 hours written notice and an opportunity to correct the violation. You understand? Yes, Your Honor. Good. Now, as for the quiet title action, I have reviewed the settlement agreement and the property records. This is a complex issue that will require a full evidentiary hearing. I am setting a trial date for October 15th. Both sides will have the opportunity to present evidence and call witnesses. We are going to settle this question of ownership once and for all. I felt a wave of relief. At least the HOA could not keep towing my car, and we finally had a trial date. The next 2 months were busy. Jennifer took depositions from Brenda Hartwell and other HOA board members, as well as from a city engineer and a representative from the title company that had handled my home purchase. I spent hours helping Jennifer prepare, going through documents and timelines. The most interesting deposition was Brenda Hartwell's. Jennifer grilled her about the HOA's authority to regulate the street, and Brenda insisted that the HOA had always treated Magnolia Lane as part of the common areas under its control. But when Jennifer asked her to produce any documents showing that the HOA actually owned the street, Brenda could not. She also could not explain why the street was listed as private in the county records, or why the city of Riverside had never accepted dedication of the street. On October 15th, I put on my best suit and met Jennifer at the Riverside County Superior Court. The courtroom was smaller than I expected, with wood-paneled walls and fluorescent lighting. Judge Mayer sat behind his bench, looking as stern as ever. The trial took most of the day. Jennifer presented our case methodically, walking through the history, the street's ownership from the original developer through the dissolution of the property management company and the settlement agreement. She called an expert witness, a land surveyor named Thomas Green, who testified about the property boundaries and confirmed that my property line extended to the edge of the street, and that according to the settlement agreement, I should own the portion of the street from my property line to the center line. Richard Pemberton tried to poke holes in our case, arguing that the settlement agreement was ambiguous and that there was no evidence it had ever been properly implemented. He called his own expert, a real estate attorney named Susan Chambers, who testified that in her opinion, the street should be considered a common area owned by all the property owners collectively, not individually. But the turning point came when Jennifer cross-examined Brenda Hartwell. Brenda took the stand looking confident, but that confidence quickly evaporated under Jennifer's questioning. Mrs. Hartwell, you testified that the HOA has always maintained Magnolia Lane as part of the common areas. Can you tell me what maintenance the HOA has performed on the street? We have arranged for street sweeping and occasional repairs. Who pays for that maintenance? The city does. We simply coordinate with them. So the HOA does not actually pay for any maintenance of the street. Well, no, but we coordinate. And does the HOA have any deed or title document showing that it owns Magnolia Lane? The street is part of the subdivision, so it is under our jurisdiction. That was not my question, Mrs. Hartwell. Do you have any deed or title document showing that the HOA owns the street? Brenda hesitated. No, but thank you. Now, you testified earlier that you have lived in this neighborhood for 20 years. In all that time, have you ever seen any document indicating that Magnolia Lane was dedicated to the city of Riverside? I assumed it was. But you have never actually seen such a document? No. And when Mr. Quinn filed his lawsuit claiming ownership of the street, did you or anyone from the HOA bother to research the ownership history before opposing his claim? Brenda's face reddened. We consulted with our attorney. Did your attorney conduct a title search or review the property records? I do not know what he did. Jennifer let that hang in the air for a moment before continuing. Mrs. Hartwell, is it true that after Mr. Quinn filed his lawsuit, the HOA towed his car a second time even though it was entirely within his driveway? He was in violation of our aesthetic guidelines. You mean his standard black Honda Accord was somehow a visual blight? The board has discretion to enforce the guidelines. And is it just a coincidence that the HOA suddenly decided Mr. Quinn's car was a visual blight after he sued you? We were simply enforcing the rules. Mrs. Hartwell, how many other vehicles have been towed for violating the aesthetic guidelines? Brenda paused. I would have to check our records. Let me help you. The answer is 0. Mr. Quinn's car is the only vehicle that has ever been towed for aesthetic reasons. Is not that true? I cannot recall every single towing incident over 20 years. Jennifer produced a document. This is a record of all towing incidents authorized by the HOA over the past 5 years, which your office provided during discovery. There are 37 incidents listed. All of them involve vehicles parked on the street overnight or blocking driveways. None of them mention aesthetic violations. Mr. Quinn's 2 towing incidents are the only ones where a vehicle was towed from a private driveway. Is not that correct? Brenda stared at the document. If that is what the records show. It is what the records show, Mrs. Hartwell. One more question. You are aware that the HOA's attorney has threatened to seek legal costs from Mr. Quinn if he loses this case. Are you also aware that if Mr. Quinn wins, he could seek legal costs from the HOA? I suppose that is possible. And you are aware that Mr. Quinn has spent thousands of dollars defending his property rights because the HOA towed his car without proper authority. He could have just paid the fine and moved on. Jennifer's voice sharpened. So your position is that when the HOA violates someone's property rights, they should just pay the fine and not fight back? Objection, Richard Pemberton said, standing up. Argumentative. Sustained, Judge Mayer said. Move on, Miss Mathies. No further questions, Your Honor. After both sides rested, Judge Mayer announced that he would take the matter under submission and issue a written ruling within 2 weeks. Jennifer and I left the courtroom feeling cautiously optimistic. I think it went well, she said, as we stood outside the courthouse. The judge seemed skeptical of the HOA's position, and Brenda's testimony really hurt their case. So what happens now? We wait. Judge Mayer will review all the evidence and the law, and then he will issue a ruling. If he rules in your favor, he will issue a judgment that officially declares you the owner of that portion of Magnolia Lane. That judgment will be recorded with the county, and it will become part of your property's chain of title. And if he rules against me, then you will have the option to appeal, but let's not think about that yet. The next 2 weeks were agonizing. I tried to focus on work and not obsess over the case, but it was impossible. I had invested so much time and money into this fight, and the principle of the matter had become almost more important than the money itself. I refused to let a power-hungry HOA push me around. Finally, on a Thursday afternoon, Jennifer called. Marcus, we got the ruling. You won. I felt my heart leap. Really? Really? Judge Mayer issued a 23-page opinion that goes through the entire history of the street's ownership. He found that the settlement agreement was valid and that ownership of Magnolia Lane should have been transferred to the property owners in 1998. He also found that the HOA never had any ownership interest in the street and had no authority to regulate parking on it. He is issuing a judgment declaring you the owner of the portion of Magnolia Lane that runs in front of your property, from your property line to the center line of the street. I let out a breath I did not know I was holding. That is incredible. It gets better. The judge also found that the HOA's actions in towing your car were wrongful and constituted harassment. He is ordering the HOA to reimburse you for all the towing fees and fines you paid, plus your attorney's fees. Wait, all my attorney's fees? All of them? The judge found that the HOA acted in bad faith and that you were forced to bring this lawsuit to protect your property rights. Under California law, that means you are entitled to recover your attorney's fees. I will submit a formal fee application, but you should get back pretty much everything you have paid me. I could hardly believe it. Not only had I won, but I was going to get my money back. Jennifer, I do not know what to say. Thank you. You are welcome. You did the hard work of finding all those old records. I just helped you present it to the court. Congratulations, Marcus. You now officially own a piece of a street. After I hung up, I sat in my living room for a while, just savoring the victory. Then I thought about what this meant going forward. If I owned the street in front of my house, did that mean I could do whatever I wanted with it? Could I paint it, put up a fence, charge people to park there? The next day, I called Jennifer back with those questions. She laughed and said, "Technically, yes, you own it, but there are some limitations. The settlement agreement requires that you allow reasonable access for the other property owners on Magnolia Lane to use the street to reach their homes. You cannot block the street or prevent people from driving on it, but you do have the right to control parking on your section of the street. So I could put up a no parking sign. You could, although I would recommend working with your neighbors rather than creating more conflict. Remember, the other property owners on Magnolia Lane should also own the portions of the street in front of their houses. You might want to talk to them and see if they want to pursue the same claim." That was a good idea. Over the next week, I went door to door talking to my neighbors. Most of them had no idea that Magnolia Lane was a private street or that they might own the section in front of their homes. A few were interested in pursuing their own quiet title actions, but most said they were happy to just let things be as long as the HOA stopped harassing everyone. One of my neighbors, an older man named Frank Morrison who lived 3 houses down, was particularly interested. He had his own grievances with the HOA and was thrilled to learn that they might not have any authority over the street. "I got fined $200 last year because I parked my RV on the street for one night while I was unloading it," he told me. "I tried to fight it, but they threatened to put a lien on my house, so I paid. If I own the street, can I get that money back?" "I do not know," I said. "But you should talk to my attorney. If you file your own quiet title action and win, you might be able to recover the fine." Frank ended up hiring Jennifer as well, and she helped him file his own lawsuit. Within a few months, 3 other neighbors had joined in, each filing quiet title actions for the portions of the street in front of their homes. Meanwhile, the HOA was not taking its loss well. Brenda Hartwell sent a scathing email to all residents claiming that I had found a loophole that threatened the stability of the entire neighborhood. She called an emergency meeting of the HOA to discuss the situation, and I attended out of curiosity. The meeting was held in the community center, a bland building near the neighborhood entrance. About 40 residents showed up, along with all 5 HOA board members. Brenda stood at the front of the room, looking angry and defensive. "I want to thank everyone for coming tonight," she began. "As you all know, we have had a very troubling development. One of our residents has filed a lawsuit claiming that he owns the street in front of his house, and unfortunately, a judge has agreed with him. This sets a very dangerous precedent for our community." Someone in the audience raised their hand. "Is it true that the HOA towed his car from his own driveway?" Brenda's face tightened. "The vehicle was in violation of our parking regulations. But if he owns the street, do not the parking regulations apply?" Another person asked. "The parking regulations apply to all common areas," Brenda said. "But the street is not a common area if he owns it," the first person pointed out. The meeting quickly devolved into chaos, with people shouting questions and arguing with each other. Some residents sided with the HOA, saying that the rules existed for everyone's benefit. Others sided with me, saying that the HOA had overstepped its authority. I sat quietly in the back, watching the drama unfold. Finally, one of the other board members, a woman named Dorothy Chen, stood up and called for order. "Everyone, please calm down. This is not productive. The fact is, the judge has ruled and we have to accept that ruling. The question is, what do we do now?" "We appeal," Brenda said immediately. "An appeal will cost tens of thousands of dollars," Dorothy said. "And there is no guarantee we would win. We might be throwing good money after bad." "So you are saying we should just give up?" Brenda demanded. "I am saying we need to be realistic. Maybe we should talk to Mr. Quinn and the other property owners and try to work out a reasonable compromise." Brenda looked like she wanted to argue, but several other people in the audience voiced their agreement with Dorothy. Eventually, a vote was taken, and the board agreed to reach out to me and my neighbors to discuss a resolution. A few days later, I received a call from Dorothy Chen asking if I would be willing to meet with the HOA board to discuss the situation. I agreed, and we set up a meeting for the following week. The meeting was much more civil than the community meeting had been. Brenda was there, but she sat silently with her arms crossed while Dorothy did most of the talking. "Mr. Quinn, we want to apologize for how this situation has been handled," Dorothy began. "The board should have done more research before taking such aggressive action. We are prepared to reimburse you for all the fines and towing fees, as the judge ordered, and we would like to work with you and your neighbors to establish a reasonable framework for how the street will be managed going forward." "I appreciate that," I said. "I never wanted to create problems for the neighborhood. I just wanted to be treated fairly." We spent the next hour discussing options. Eventually, we agreed that the property owners who owned portions of the street would form a road maintenance association separate from the HOA. This association would be responsible for maintaining the street and would have the authority to set reasonable rules about parking and access. The HOA would no longer have any jurisdiction over the street. It took several more months to formalize the agreement and create the new Road Maintenance Association, but eventually, everything was settled. I received a check from the HOA for $425, plus another check for $11,300 to cover my attorney's fees. Frank and the other neighbors who had filed their own lawsuits also received judgments in their favor. Brenda Hartwell resigned from the HOA board shortly after all this concluded. I heard through the neighborhood grapevine that she was furious about the whole situation and blamed Dorothy and the other board members for not supporting her more strongly. Dorothy became the new board president and immediately began working to reform the HOA's practices and make them more transparent and resident-friendly. As for me, I finally felt like I could relax and enjoy my home. I still had the title to the section of street in front of my house, which was recorded with the county and would be part of my property if I ever sold. It was a strange thing to own a piece of a street, but it also felt like a vindication of my rights as a property owner. One Saturday afternoon a few months later, I was washing my car in the driveway when Frank stopped by. He was grinning from ear to ear. "You are going to love this," he said. "I just got off the phone with the county assessor's office. Because I own the street in front of my house, they are reclassifying my property and I am going to get a small reduction in my property taxes. It is only about $80 a year, but still," I laughed. "That is great, Frank. Every little bit helps." "You know, Marcus, when you first told me about all this, I thought you were crazy. Fighting an HOA over a parking space seemed like a waste of time and money. But you were right. Sometimes you have to stand up for yourself, even if it is hard." "Thanks, Frank. I appreciate that." As Frank walked back to his house, I thought about everything that had happened over the past year. It had been stressful and expensive, and there were times when I wondered if I was making a mistake. But in the end, I was glad I had fought back. The HOA had been wrong, and they needed to be held accountable. I also learned something important about property ownership. When you buy a house, you are not just buying the building and the land it sits on. You are buying a bundle of rights that can be complicated and sometimes surprising. Most people never think about things like easements, title defects, or who actually owns the street in front of their house. But those details matter, and it is worth taking the time to understand them. That evening, I parked my car in the driveway, making sure it was well back from the property line, even though I did not have to worry about that anymore. As I walked into my house, I felt a sense of satisfaction that went beyond just winning a legal battle. I had learned to navigate a complex system, to stand up for my rights, and to not back down in the face of unreasonable authority. The whole experience also made me more aware of the importance of community. While I had been fighting the HOA, I had gotten to know my neighbors better. Frank and I became good friends, and several other people on Magnolia Lane started organizing neighborhood barbecues and get-togethers that were separate from the HOA's official events. We formed our own little community within the larger subdivision, and it was built on mutual respect and cooperation rather than rules and fines. Of course, not everyone was happy with how things turned out. A few residents who were close to Brenda still glared at me when they saw me at the mailbox or driving through the neighborhood. But most people seemed relieved that the conflict was over, and that the HOA was being run more reasonably under Dorothy's leadership. About 6 months after the trial, I received a letter from Richard Pemberton, the HOA's attorney. For a moment, I worried that they were going to appeal after all, despite the agreement we had reached. But when I opened the letter, I was surprised to find that it was actually an apology. "Dear Mr. Quinn," it read, "I am writing to express my personal apology for my role in the legal dispute over Magnolia Lane. As an attorney, I should have conducted more thorough research before advising my client to take aggressive action against you. Upon reflection, it is clear that you were in the right, and the HOA's actions were not justified by the law or the facts. I hope there are no hard feelings, and I wish you the best going forward. Sincerely, Richard Pemberton." I was touched by the letter. It took integrity to admit when you were wrong, especially for a lawyer who had fought hard on the other side. I wrote back thanking him for the apology and saying that I held no grudge. As time went on, the whole incident became just another story in the history of the neighborhood. New residents moved in who had no idea there had ever been a dispute over the ownership of the street. The road maintenance association that we had formed functioned smoothly, with minimal drama. We met once a year to discuss any maintenance issues and to split the costs of things like pothole repairs and street sweeping. It was a far more democratic and reasonable system than having the HOA dictate rules from on high. I continued to live in my house on Magnolia Lane, enjoying the peace and quiet of suburban life in Riverside. I got a promotion at work, started dating a woman named Sarah, whom I met through a mutual friend, and generally settled into a comfortable routine. The whole HOA saga became a story I told at parties, and people always seemed amazed that such a thing could happen. One thing I made sure to do was to help other people who contacted me with their own HOA horror stories. After the local newspaper ran an article about my case, I started getting emails and phone calls from people all over California who were having disputes with their HOAs. I could not help everyone, but I tried to point them in the right direction, sharing Jennifer's contact information and explaining what I had learned about property rights and HOA authority. I also became more active in local politics, attending city council meetings and advocating for reforms to how HOAs are regulated in California. I learned that there are very few state laws governing what HOAs can and cannot do, and that gives them tremendous power over homeowners. I joined a group called the California Homeowners Alliance that was pushing for legislation to increase transparency and accountability in HOA governance. It was not glamorous work, but it felt important. I had been lucky enough to have the resources and the determination to fight back when the HOA overstepped its bounds, but many people are not in that position. They cannot afford to hire an attorney or take time off work to go to court. They just pay the fines and live with the frustration, feeling powerless against an organization that is supposed to be working for their benefit. One of the bills that the California Homeowners Alliance was pushing would require HOAs to provide 24 hours notice before towing any vehicle, and to allow the property owner an opportunity to contest the towing before it happens. It seemed like common sense to me, but the bill faced opposition from HOA management companies that argued it would make enforcement too difficult. We were still working to get it passed as of last year. Looking back on everything, I sometimes wonder what would have happened if I had just paid that first $425 fine and moved on with my life. I would have saved myself a lot of stress and probably a fair amount of money, at least in the short term. But I also would have let the HOA continue to abuse its authority, and I would have missed out on an important lesson about standing up for my rights. The experience taught me that just because someone claims to have authority does not mean they actually do. The HOA acted as if it had the right to tow my car, but when I challenged them, it turned out they had no legal basis for what they did. How many other people had been pushed around by the HOA over the years simply because no one had bothered to question their authority? It also taught me the value of doing your own research. If I had not spent those hours digging through property records and old legal documents, I never would have discovered that I owned the street. Most people would have just assumed the HOA was right and paid the fine. But I was curious and stubborn enough to keep digging until I found the truth. And finally, it taught me that the legal system, for all its flaws, can still work to protect individual rights. Judge Mayer could have easily dismissed my case as a frivolous waste of the court's time. But he took it seriously, reviewed all the evidence, and issued a thoughtful ruling based on the law and the facts. That gave me a renewed faith in the justice system, even though I know it does not always work out that way. A year after the trial, I was sitting on my front porch on a Sunday afternoon, drinking a beer and watching the neighborhood kids ride their bikes up and down Magnolia Lane. Sarah was inside making dinner, and I could smell something delicious wafting through the open window. It was one of those perfect moments where everything felt right with the world. Frank walked by with his dog, a golden retriever named Max, and waved. "Hey Marcus, you coming to the Road Maintenance Association meeting next week? Wouldn't miss it," I called back. "Good. I want to talk about getting some speed bumps installed. These kids ride their bikes way too fast." I laughed. "I will see you there, Frank." As I sat there, I thought about how far things had come. A year ago, I had been angry and stressed, fighting a battle that sometimes felt hopeless. Now, I was at peace, living in a neighborhood that felt more like a real community. The HOA still existed, but it was run more reasonably now, and it no longer had the power to intimidate people. I also thought about Brenda Hartwell and wondered what she was doing. I had heard she moved to Arizona to be closer to her daughter. Part of me felt sorry for her. She had probably genuinely believed she was doing the right thing, enforcing rules for the good of the neighborhood. But she had gotten so caught up in the power and authority of her position that she lost sight of basic fairness and respect for people's property rights. It was a lesson I hoped I would never forget. Power, even the small amount of power that comes with being on an HOA board, can corrupt people if they are not careful. It is easy to start believing that you know what is best for everyone, and that the rules exist for their own sake rather than to serve the people they are supposed to protect. As the sun started to set and Sarah called me in for dinner, I took one last look at the street in front of my house. My street. It still felt strange to think of it that way, but it was also satisfying. It was a reminder that I had fought for something important and won. I stood up, finished my beer, and headed inside. The smell of roasted chicken and vegetables filled the house, and Sarah was setting the table. She looked up and smiled at me. "You look happy," she said. "I am," I replied, "just thinking about how lucky I am." "Lucky? After everything you went through with the HOA?" "Yeah, lucky. Because I learned that I can stand up for myself and win. Not everyone gets to learn that lesson." She came over and kissed me. "Well, I am glad you learned it, but let's try to avoid any more legal battles for a while, okay?" I laughed. "Deal." We sat down to dinner, and as we ate, I told Sarah about the Homeowners Alliance meeting I was planning to attend later that week. She listened patiently, even though I knew she was not as passionate about HOA reform as I was. But she supported me, and that meant everything. After dinner, we went for a walk around the neighborhood. As we passed other houses on Magnolia Lane, I pointed out which ones belonged to the property owners who had also filed quiet title actions. Frank's house, of course, and the Johnsons 2 doors down, and the elderly couple at the end of the street whose names I could never remember. "It is funny," I said to Sarah. "A year ago, I barely knew any of these people. Now, I feel like we are all connected in this weird way, like we went through something together." "That is what communities are supposed to be," Sarah said. "People who look out for each other." She was right, of course. The whole experience had brought us together in a way that HOA-sponsored events never could. We had formed bonds based on mutual support and a shared sense of justice, rather than just living near each other. As we walked back to my house, I felt a deep sense of contentment. Life was good. I had a job I enjoyed, a woman I loved, friends in the neighborhood, and a house that was truly mine, including the street in front of it. The HOA drama was behind me, and I could focus on the future. But I also knew that I would never forget what I had learned. I would always be the person who questioned authority, who read the fine print, who stood up for his rights even when it was difficult. And if another HOA or any other organization tried to push me around, I would be ready. That night, as I lay in bed next to Sarah, I thought about all the people who had helped me along the way. Jennifer, who had believed in my case even when it seemed far-fetched. Frank and my other neighbors, who had supported me and followed my lead. Judge Mayer, who had taken the time to carefully consider the evidence and issue a fair ruling. Even Richard Pemberton, who had ultimately shown the integrity to apologize when he realized he had been wrong. I also thought about the people who had opposed me. Brenda Hartwell, who had been so certain she was right that she never bothered to check the facts. The HOA board members who had enabled her behavior. The towing company that had taken my car without questioning whether they had the authority to do so. All of them had taught me something valuable, even if they had not meant to. They had taught me that injustice happens not just because of evil people, but because of ordinary people who do not ask questions, who follow rules blindly, who assume that authority is always legitimate. And they had taught me that one person, armed with the truth and the determination to fight for it, can make a difference. It might take time and it might be expensive and stressful, but it is possible. The system can work if you are willing to work the system. As I drifted off to sleep, I smiled. Tomorrow was Monday and I would go back to work, dealing with code and deadlines and meetings. But I would also be the person who had taken on an HOA and won, who had discovered he owned a piece of a street, who had stood up for his rights and come out on top. And that was a pretty good feeling. The next morning, I woke up early and went for a run before work. As I jogged down Magnolia Lane, I felt a sense of ownership that went beyond the legal title recorded at the county courthouse. This was my neighborhood, my street, my community. And I had fought to keep it that way. When I got back to the house, I found an envelope in my mailbox. It was from the HOA, and for a moment, my old anxiety returned. But when I opened it, I found that it was just the monthly newsletter, full of announcements about upcoming events and reminders about trash pickup days. Nothing about fines or violations or parking regulations. I breathed a sigh of relief and headed inside to shower and get ready for work. As I stood under the hot water, I thought about how much had changed in just a year. I had gone from being a passive homeowner who paid his dues and tried to stay out of trouble to being someone who understood his rights and was not afraid to assert them. It was a transformation I had not expected, but one I was grateful for. And as I dried off and got dressed, I made a promise to myself that I would never go back to being passive. I would always ask questions, always stand up for what was right, always be willing to fight when necessary. Because in the end, that is what freedom really means. Not just the absence of oppression, but the willingness to resist it when it appears. And I had learned that lesson the hard way, fighting an HOA over a parking space and discovering that I owned the street. It was a lesson I would carry with me for the rest of my life.